What happens when a young man raised in chaos stands before the court, not just for what he did, but for everything that's broken behind him? In today's gripping case, we meet Aaron Nathaniel Guillory, a man charged with robbery and unlawful possession of a weapon. But as the facts unfold, it becomes painfully clear this isn't just about crime. It's about trauma, abandonment, and the long shadow of addiction. The prosecution is pushing hard for prison time, but the defense claims he's more follower than felon. Then comes the emotional twist. His mother reveals he was born addicted to drugs. You won't believe how Judge Boyd responds. There are no villains here, just pain, choices, and consequences. Should he be punished or protected? Stick around, because this courtroom tale will challenge everything you think you know about guilt and redemption.
All right, the court is calling 2025 CR 002636, State versus Aaron Nathaniel Guillory. Can I have parties announced?
Megan Galloway for the state.
And Eric DeWalt, and I represent Mr. Guillory.
And are you Aaron Guillory?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client?
I did, evidenced by my signature on that.
Court will find that the state is in compliance with discovery. There are no applications.
Your Honor.
Mr. Guillory, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 3. And then regarding counts 1 and 2, we would like to proceed on the lesser included offense of robbery.
Here's something important for viewers who aren't familiar with legal strategy. The state drops count 3 and chooses to proceed on lesser included offenses for counts 1 and 2. What does that mean? Instead of pursuing harsher charges, likely aggravated robbery, the prosecution is offering a kind of compromise, basic robbery without the A enhancement. This tactic is often used when the evidence might not support the more serious charges or when the defendant is open to a plea deal. It's a clear signal. They're looking for a conviction, but not necessarily maximum punishment.
It's this way. So, count 1.
Proceed on the lesser included offense of robbery.
And count 2.
Proceed on the lesser included offense of robbery.
Count 3.
Waive count 3, Your Honor.
Any objection?
None, Your Honor.
Count 4.
Proceed as is, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in counts 1, 2, you're charged with robbery. In counts 4, you're charged with unlawfully carrying a weapon with a felony conviction. Those offenses range of punishment is anywhere from 2 to 20 years in prison.
This is where reality hits hard. The judge explains that robbery and unlawful weapon possession carry a 2 to 20-year sentence and up to $10,000 in fines. Imagine facing that at age 20. Think about it. Should someone who may have simply followed a bad crowd serve 2 decades in prison? Or does he deserve another shot? Let us know in the comments. Is the punishment too harsh or just right?
And up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have pleas with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in each one of these in each one of these counts?
Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of?
Here the judge checks the essentials: mental fitness, coercion, and plea validity. It's a crucial moment. If Aaron had been coerced, or mentally incompetent, the plea wouldn't stand. But he affirms everything under oath. So what we're looking at isn't confusion or manipulation. It's a young man who knowingly walks into a guilty plea. That makes what comes next even more tragic.
There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It was, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one of the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count two to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
To unlawfully carrying a weapon with a felony conviction, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of count one, guilty of count two, guilty of count four. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, and you believe your client is competent?
I do, Your Honor.
Mr. Guillory, how far did you go in school?
I'm great.
Why did you drop out of school?
Thank you, Your Honor.
I didn't drop out. They didn't.
This is where the courtroom shifts from cold legal procedure to raw personal struggle. The judge presses Aaron about school, and his answers are heartbreaking. He wasn't expelled. He was discarded by the system for getting in trouble. But what does that mean? He admits it. I wanted to fit in. This isn't just a legal case. It's a portrait of what happens when broken kids fall through the cracks. And yet, he still takes ownership, saying, I know what I'm doing. That mix of honesty and hopelessness, it's hard to watch.
I'm doing okay. How are you doing?
Good, man. I'm doing all right.
All right. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. Can you lower your hand? If you'll state your name for the record.
Barbara Bates Hillary.
All right. So can you tell me, what is his issue? Why didn't he finish school?
Well, first of all, I adopted him. That's my great nephew. I adopted him. He was a drug baby. His mom was on cocaine and all. After I adopted him and stuff, and he finally came up out of having convulsions, all of that. And then he went to school. Being with the wrong crowd to me. Because as far as upbringing, he was raised right. So
you're saying that he was a drug baby. Are you saying that his mom used drugs while she was carrying him? All right.
yes, ma'am.
And then was he born addicted to drugs?
Yes.
Boom, here it is. The emotional center of the entire case. Aaron was born addicted to drugs. His great-aunt turned adoptive mother describes how he would scream through withdrawals as an infant, crying for drugs he couldn't understand. This changes everything. It adds a tragic lens to his misbehavior, his choices, even his crimes. Imagine starting life that way and still being expected to function normally. Should the court treat that as a mitigating factor? That's a question for all of us.
Listen,
And where's the grandmother, his grandmother? Do you know?
he's dead.
Okay.
He's dead.
All right. All right. Thank you so much for telling me some things about him.
Thank you.
All right. Thanks.
A few moments later.
All right. So we are back on the record. And so the state has amended their offer to a cap of 6 years in the prison. Is that correct, counsel?
It is, Your Honor.
All right. So what I can tell both parties is I have worked on the CPS side before, and children who are born addicted to drugs And this is why I tell parents, when you're using drugs and you're carrying a child, it's just like that child is using drugs. And when children are born and all of that, they have withdrawals. And the only difference between their withdrawals and an adult's withdrawals, they don't know why they're in pain. And those babies, and everybody should get a chance to go to the hospital and volunteer, because those babies just scream incessantly and they're in pain, and there's no amount of rocking that you can do to stop them from screaming, because they're born addicted to drugs, they're having withdrawals, and then they want drugs, but they don't know what they want. And giving them milk, rocking them, doing the skin to skin contact does not soothe them because they want drugs. So with regard to your client, I now understand why there were issues with him and why he was not allowed to return to school at 9th grade, because he was born addicted to drugs, and nobody knows. They have sort of an idea of what the drugs will do to your brain, but not really. So no.
Judge Boyd takes a moment here to deliver one of her most emotional reflections yet. She talks about babies born into addiction and the invisible pain they carry. It's one of the few times we see a judge pull back the curtain on human suffering beyond the facts of the case. This isn't just about Aaron. It's about a system of neglect and trauma. Her point is powerful. Babies don't get a choice, but they pay the price. And sometimes that price is prison.
Nobody knows what that will do to your brain. So the state has agreed to do a cap of 6 years. And what I can tell you from reading the police report, it appears that the co-defendant is saying that someone owes him money or owes him something. And instead of calling the police, this co-defendant goes out to take that person's motorcycle, which that person didn't end up with the motorcycle. And he brings your client along to get this motorcycle.
You read it correctly, the way I saw it.
So do you want to argue with regards to the cap of 6?
I would, Your Honor. May I?
Yes.
May it please the court. In speaking with my client and speaking with his grandfather and his mother, I know that in the fact pattern, Mr. Guillory was a follower, a hanger-on, and he was with other individuals and found himself in a situation.
Aaron's defense team makes a strong pitch here. They're not denying his involvement. They're arguing context. He was a follower, a kid pulled into a robbery over someone else's grudge. And crucially, they claim he was cooperative, rational, and aware of his actions. It's a rare kind of plea, not an excuse, but an explanation. The attorney even asks for a downward departure, a legal term for a lighter sentence than originally agreed. Do you think Judge Boyd will buy it?
Been a cooperative individual with me. He's been able to go over the fact pattern with me and go over all the stipulations. So at this time, we'd ask if the court would have a downward departure in any way. It would greatly be appreciated.
All right. This is what the court is going to do. As previously stated, the court is finding you guilty to count 1, counts 2, and counts 4. And each count, the court will sentence you to 3 years in the prison, give you credit for any time served. The counts will run concurrently. There's a $2,000 fine. Time and money will.
And just like that, Judge Boyd cuts the sentence in half. Instead of 6 years, Aaron gets 3 years served concurrently. That's a big win for the defense, but it also says something deeper. The court sees him as more than just a criminal. She adds a $2,000 fine and bars him from contacting the victim. But more than that, she gives him wisdom, not just a warning. Call your great aunt before you act. That moment, pure mentorship disguised as justice.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. So let me explain something to you. Any action that you're getting ready to take that somebody wants you to participate in, before you participate in it, call your great aunt who adopted you and tell her, this is what they're saying. Do you think I should go along with this? Because people will involve people in things because sometimes the world is not a nice place. People don't care about your upbringing or what has happened to you. They will involve you in whatever they're trying to do. We can go off the record. I've had cases before as a defense attorney and as a prosecutor. You know what ends up happening? They used to call them SAPs, right? We'll let you go in and get the money. We'll let you go in and do this. And then they just sit and wait for you to come out. And if you get arrested, oh, well, they leave you. And then you're stuck with all the charges. Do you understand?
Yes, sir.
So you had better recognize who loves you, who's there for you. And if you have a question on whether what, well, not even if you have a question, any decisions you make, call your great aunt. You understand?
Yes, sir.
All right. Good luck to you.
This case wasn't just about robbery. It was about the layers behind every bad decision. Aaron Guillory pleaded no contest to robbery and weapon possession, but behind those charges was a lifetime of pain, addiction, and neglect. Judge Boyd delivered a rare balance of justice and mercy, reducing his sentence and giving him advice that could save his life. If there's one takeaway, it's this: the law punishes, but sometimes it also tries to heal. That if you want more real courtroom moments broken down, hit subscribe so you never miss a session.